Hey everybody, it's Dr. Jensen. We've made it! The end of Module 5. So here we are at Part 6 of Media and Courts. So this is the very end of the module. We're going to be getting some solutions and strategies here, so this is a great way to close. Let's go ahead and jump in. So here we have fixing pretrial publicity, excuse me. We already know the research says it's there. We showed the research that says it matters and it does have an effect. So how do we control or correct it? What strategies do we use to fix the PTP problem? And then what roles do experts play in the court in assisting in this issue? And then finally, we're going to spend a little bit of time on shield laws at the very end. So let's jump in. We have two sets of measures, and these are detailed heavily in your textbook. So if you go to box 6.3 in chapter 6, you can see a little chart that, and box 6.4, by the way, two charts that show you the proactive measures and the reactive measures. So I invite you to take a second look at that chart so you kind of can use that to review. So the first proactive measure we're going to talk about is closure. What's closure? It's basically isolating judicial proceedings from outside attendance. So no media, no access, you're done. So absolutely no coverage. And you can imagine it's highly effective. You're not allowed in here, so how can we possibly publish and produce information on this if we don't get access to it? Highly effective, but rarely used. Think about a judge would have to basically demonstrate the need for this closure, and the media are going to argue that judge and say, hey, we are proxies for the public, and you got to let us access to get in there because it's part of our First Amendment right to do so. It's obviously the most restrictive measure by a judge, but it is subject to protest by the media due to its limiting watchdog function it gets to use. So again, the watchdog function the press provides, freedom of the press, is under the First Amendment, and it would be subject to arguments in Supreme Court appeals. So a judge would have to prepare him or herself to all the challenges against closure. So again, very rarely used, but it would actually completely eliminate the pretrial publicity problem. So because closure isn't really a good option, we move to another one, which is a restrictive order, another proactive measure. So restrictive orders prevent the media from printing or broadcasting information. Media can still attend and learn, but they cannot report. So when you think about it, it's kind of like putting a gag order on a reporter. Well, you can still find out stuff, but you can't report anything until after all of this is said and done, so it doesn't have undue influence on what's happening right now. So we call them gag orders, prior restraint orders. You put a gag order on the press. So essentially, most courts have upheld the right of the media to publish their discoveries, and so it's highly challenged, again, just like closure. But at least it gives them access to the information. It just doesn't let them report it. So again, this is subject to those First Amendment challenges, and generally we see that Supreme Court appeals on this are upheld. So again, not necessarily a useful way to go about this because of these constitutional challenges. The very last of the proactive measures are protective orders. So a protective order prohibits the attorneys and other trial participants, like the courtroom work group and others, from making statements or comments outside the courtroom. So essentially, instead of gag ordering the press, you're gag ordering the attorneys. And the argument for this, essentially, by the judge is this: participants possess privileged information about the case, which is exempt from First Amendment appeals. So because it would have undue influence on the trial and the significance and importance of it, we have to withhold some of that information from the press. So it would obviously be the easiest proactive measure to implement, but it might be the least effective because, again, media can still publish their discoveries. And you really can only best utilize it in the early stages. So a judge would have to be so on her or his game to get way in front of anything that a reporter would possibly publish, to put a protective order in place very, very early. And we know the chances of that are slim to none. There is such pressure on the press for many, many reasons to break the story and to scoop each other. And so they're going to try to seek access to everybody that it can to really get the inside scoop. And so a judge has to basically be a media warrior in front of being a judge to try to keep this all from happening. But that is essentially what we have with protective orders. So again, these don't get implemented very often. Let's talk about the ones that do, and those are our reactive measures. Okay, reactive measures are 5 different things we can do. Voir dire, which again is jury selection. Jury instructions by the judge. Sequestration, which is essentially isolation. Continuance, and change of venue. So we're going to talk about each of these so you know how they work. So the first one is voir dire. Attorneys and or judges will question potential jurors after they are summoned to a court about the biases that they may hold that would prevent them from hearing the case fairly. So in cases with pretrial publicity, extended questioning may be allowed, where we're really trying to make certain that they don't have this undue influence over our jurors, okay? So we got some problems here. There are problems with effectiveness. Okay, we're putting a lot of faith in the attorneys and the judges' ability to question the jurors and jury selection. And we know that they're human beings and they're not going to remember everything, they're not going to ask everything. And especially the attorneys, they're coming at it kind of as a loaded gun with these potential biases in their head and maybe only focusing on those and those getting in the way of other potential biases that they should also ask about that are also relevant, but again, just not forefront in the center of their brain. So we're kind of limited by that person's ability to keep track of all that, which is a daunting task. Of course, attorneys and judges do the very best of their ability on behalf of their clients and the people, but again, there's a lot at stake here. There has to be some other thing we can do to ensure the questioning will go a lot more smoothly. And then another problem we have are, do jurors know their own biases? Evidence shows us from psychology literature that no, we don't. It's hard for us to really recognize what our own biases are. We can, but after a lot of diligent searching and a lot of kind of personal revelation. So that's an issue. So if a judge finds that pretrial publicity is in a case and says, do you think this will bias you? Well, how is the juror supposed to say whether it will or not? They don't know. We also have recall issues. So essentially, if you're asked, did you see that Dateline or did you see that viral Facebook video about the arrest? Did you see that and, did it influence you? And you go, wow, I don't know if I saw that on Facebook. I don't know if I watched Dateline or if it was some other program, but I know I saw it. So you forget because, again, we are inundated with media from so many different sources. It's hard for us to keep track of exactly what detail came from what network or what source. So we're going to forget. We're going to have some recall bias. And then finally, can jurors be accurate in reporting that pretrial publicity will not affect them? So let's say you admit, yes, I've been exposed to pretrial publicity, and no, I'm not going to let it influence me. I'll do the very best, Your Honor, to really let the facts play out and not prejudge the defendant. Well, we actually had a funny story about this. So Dr. Levitt here in our department has a mentor that extensively published on pretrial publicity and is an expert in this research. And her spouse was summoned to jury duty. And it was a case that had a lot of pretrial publicity. So the judge is asking the question to her spouse, okay, you've admitted that you've received pretrial publicity. The spouse said yes. Is this going to impact your ability to be fair and impartial? And the spouse says, well, of course, I would do my very best to try to suppress anything that might influence me as a juror. But then, however, my wife has extensively published on this and has pretty much documented that I don't have a very good ability in doing that. So I guess my answer is no, I can't really suppress that. And so the judge laughed hysterically. Okay, yeah, you're right. And eventually her spouse was dismissed from the jury summons box, and that was that. So it was kind of funny to say, I've read my wife's research and she says I can't. So I guess not. But to me, it would be funny to see what the other jurors had to say that were eventually selected in that case. Let's talk about another reactive measure, judicial instructions. This is when the judge gets to talk to the jury and remind them of their responsibilities to rule on the facts alone and let that bear the most weight in their decision to convict or what have you. So the judge tells the jurors to avoid being influenced by PTP, and that's part of the final jury instruction that is received. And it's important to rely solely on the trial evidence and the trial evidence alone. Well, that's maybe helpful, but is it effective? Not so much. Jurors are generally not really great predictors of what affects their behavior because a lot of things happen in the moment and we just can't see into the future. So a judge says this 2 minutes before you go into deliberation, you might forget what the judge said. Jurors also generally do not follow judicial instructions to disregard inadmissible evidence, and research has demonstrated this. So even though the judge said, hey, this evidence inadmissible, it was illegally obtained, you have to forget you saw it, it was presented in court, but I dismissed it, it still is in their brain. It's very hard to dismiss something you saw and say, wait, I can't consider that, and keep that at bay. Very, very difficult to do. So providing a rationale may help, but we have this backfire or this boomerang effect with it still lingering on in our thoughts. And essentially at the bottom here, we have Schneider and Wegener's research, two psychologists, that say, you know, when the judge tells you not to do something and to keep it off your mind, it's really hard to keep it off your mind because they just said it. And their research was kind of fun, where they had a group of people in a lab study that said, okay, whatever you do, we don't want you to think about a white bear. Well, of course, what did they think about? They thought about a white bear. It's very hard to suppress a thought once it's been introduced by someone else. And they demonstrated that if the judge says, don't be influenced by pretrial publicity, well, what are they going to think about? Okay, I don't want this to influence me, or this, or this, or this. I mean, that's just going to happen. So we have good research to suggest that this is not necessarily effective. Another one that we have a problem with implementing is sequestration. We're going to sequester the jury. We're going to put you in a little box. We're going to isolate you and contain you from everybody and everything else so that you are not influenced. So essentially, jury isolation or quarantine to control the information that the jury receives. Wow, that's a bold move, and we have some problems. So problems with effectiveness, it only works really if the jury has not been exposed to pretrial publicity prior to being impaneled by the judge after that voir dire jury selection. Because you can't isolate what's already there, right? It's also very costly, and when you think about, okay, you are all going to stay in this hotel room and you have to stay together and you can't leave, it adds a lot of cost burden to the trial, and it's very disruptive to the jurors' lives. I mean, they can't talk to anyone, they can't see anybody, you know, it's kind of like they're in prison. And, you know, juror deliberation and the emotions and the highs and lows that go with a jury process requires support and requires a lot of help so that you're not overwhelmed and frustrated by everything and having all that emotion influence what you're thinking and feeling about all the evidence that you're seeing. And so maybe that kind of stress and anxiety would not be helpful to the jury. We also have it potentially generating animosity toward the accused due to their containment. Well, if only we could just convict this guy, I could get out of this stupid box and see my family again. So you could see how it might kind of push them into biases toward the defendant, where they feel like because of you, I've been isolated. And they're kind of putting the blame on that crime that that person may or may not have committed. So sequestration is least effective of the reactive measures, as you can imagine. We also have a continuance. This one is interesting. So continuance is essentially playing with time, delaying the start of a trial, hoping that all that PTP will die down. So giving people a chance to let other things take the media center stage and dilute the landscape a little bit so that maybe it's kind of a little bit more forgettable or in the back of our mind and not as important to us because other things have taken its place. That can be useful to kind of, you know, take the heat off everybody for a while, but there are some problems with effectiveness here too. So some studies will show what we call a sleeper effect. Well, yeah, it's in the back of our mind, but it's still there, and suddenly when the trial comes, it's front and center again. So you have a tendency to be more influenced by unreliable information over time as the memory for the unreliable source becomes detached from the information. And so it kind of, again, rears its ugly head. And then sometimes, because it's been suppressed, we introduce new responses, new perceptions of it, including inaccuracies. So we don't remember it as accurately as we thought we did. So now we have even more bias because we thought we remembered it this way. That's not actually what the article or the report said. Oops. So it may work for factual pretrial publicity when we're trying to get these facts off the table, but you have to remember the effects of that emotional pretrial publicity are quite pervasive over time. You guys have seen some images from our last lecture. Some of those images are almost impossible to erase. They are so incredible And the image that comes to my mind is the firefighter holding the infant that's dead from Timothy McVeigh's act of terror that he was convicted on. I don't think I can ever forget that image. I mean, again, Pulitzer Prize winning image. How do I suppress that and hope that will die down? I don't know that it ever will. So we really need more empirical work, and when we say the fancy word empirical, we're talking about observation and evidence-based research that shows us that this either is effective or not. So we're looking for more studies on this to see kind of if it is very useful as a strategy. The other reactive measure we need to talk about is change of venue. Aha, this is the good one, and we've kind of mentioned this in prior modules. So change of venue may be granted in this term. So if a court is satisfied that there exists in the district where the prosecution is pending so great a prejudice against the defendant that the defendant cannot possibly obtain a fair and impartial trial at any place fixed by law for holding court in that district. So it recognizes that the location is problematic, right? And this may be supported by some field studies comparing jurisdictions. And we talked about some of those in part 5, where we were able to demonstrate that there was maybe not an elimination of pretrial publicity, but there was less, which again could make the difference. So this also highly depends on the extent of pretrial publicity, how pervasive it is, and the type of pretrial publicity, the emotional versus the factual. Those images say 1,000 words, we have to think about stuff like that, and whether it was pro-prosecution or pro-defense. So we have to think about the kind of case specific we have, the general, the emotional and factual, but this could actually be a useful strategy. So a little bit more on change of venue. Research suggests that this is the most effective method. Move the trial. It can be a little costly when you think about it, but it doesn't get challenged very often, and it can be pretty effective where you actually just deal with the exposure itself and move it to a place that doesn't have as much exposure or has no exposure. Now we have a winning situation. Okay, so in certain cases, a different menu may also be tainted. So again, for the really high-profile celebrity cases like O.J. Simpson or Timothy McVeigh with the Oklahoma City bombing, there is not a person on the planet that didn't know about those cases at the time. So how do we possibly find a change of venue that's suitable for those cases? But again, we look for a distinguishment between the amounts and types of PTP that could be useful. So looking at the amounts and types of PTP may differ enough, just enough to make a difference and approximate a fair trial in good faith, so that we have that due diligence on our side. So those are all the measures, proactive and reactive, we have to talk about. But finally, we're going to wrap up with two things: the role social scientists play in court, as well as shield laws. So let's talk about that. So what do we do as social scientists when we are bringing forward this research and so forth? Well, essentially, social scientists provide expert testimony and research to test concerns about fairness and media being involved in a case, and suitability of witnesses, of people to testify, and so forth. So social scientists actually play really large roles in the court system, especially when we're trying to determine fitness for examination, people's mental health. We are often brought in for those. We testify on law quite often, but again, that research is essential. We also will answer these kinds of questions in the case of media. So how does pretrial publicity actually influence juror decisions? And this research will be brought forward by attorneys to demonstrate the concern. And then again, we can look at what kind of pretrial publicity is actually out there and help in identifying what's out there. And finally, what is the community sentiment or potential bias that we need to worry about? So we can analyze all this publicity and put forward basically a report that shows really what conclusions we would come to and potential biases. So finally, we're going to wrap up with shield laws, and to me this is a really interesting way to wrap up because it kind of flips the script on what we've been talking about. So shield laws are kind of back on the journalist side. We're moving away from the social scientists, but it's a journalist's claim of privileged conversations, and they're being prevented from divulging their sources. So it's similar to that attorney-client privilege or the doctor-patient privilege, where they have to protect the privacy of the people they're talking to. And this is where we say, I'm going on the record, I'm going off the record. I'm coming forward as a source for somebody. So in order to be a good watchdog, the press says we must be protected from revealing our sources because it could compromise the kind of reporting we do. It could jeopardize this person's life, and we need to protect their identity. There are some problems with this, however. So in today's 21st century media landscape, who is a journalist? Is it a blogger? Is it someone that posts regularly on Facebook? Is it someone with a cell phone camera in their pocket? Who's a journalist? And what is journalism really? How do we officiate and authenticate real journalism? Is it just simply publishing and disseminating commentary on things? So we have to sometimes constantly redefine this changing landscape of what media is. Also, we run into this problem. What about subpoenas from a judge? What about warrants from law enforcement for searches and seizures that are going to leak out, things like WikiLeaks, your sources? Generally speaking, with exceptions from time to time, if you are subpoenaed or issued a warrant, you have to divulge your source. Now, media do not like this, and it is challenged all the time. And we've even had some journalists risk being arrested and incarcerated in order to protect their sources and not agree or abide by the subpoena or the warrant. And this has been challenged quite a bit. Now, also, there are 40 states that currently have shield laws in place to protect journalists from revealing their sources. And these have some variation from state to state, so those would be problems as well. But what about the national and international coverage of news? You know, we have these boundary issues. Well, this is really a national story. Well, who has jurisdiction over a national story or an international story for that matter? So what shield laws would protect what journalist in what circumstance? So again, very problematic stuff. But I want to read a quick quote from Surratt, because I think it's a pretty telling way to wrap up our discussion on shield laws. And this is what he has to say. He said, "The media's efforts have made obtaining their information more costly, time-consuming, and difficult, and in that sense, they have successfully increased control of their knowledge and the release. But like the courts themselves, the media are now also more open to inspection and more often pressed for access and information from non-governmental sources, such as citizens and lobby groups." So ironically, the very process of access that the media initiated in court has actually cycled back to affect their own social reality. So that wraps up our media and court module. I hope you enjoyed looking at all these fundamental rights and all the research and everything out there. And thank you for participating. Let me know if you have questions. Bye-bye.